I will call the August 23rd Select Board meeting to order at 11 a.m. We are still missing Matt, but I'm not sure if you all want to get started. I'll be recusing for the discussion on the real estate related articles or short-term rental related articles. And then I'll come back into, I guess, sort of are we going to ratify our adoption of the warrant after this is all worked out?
I guess that would be a question for John if we need to do that.
Yes.
I'm assuming you need me for sort of the final vote at the end. Okay.
Yes.
All right. Well, I'm going to turn my camera off and recuse and hand it over to you, Brooke.
Okay. Thanks, Don. Do we know if Matt's coming? Has anyone heard anything?
Tom and I were just on a meeting with Matt and we said, see you in a few minutes. And he.
Okay. All right.
No, I'll text him.
Yeah. Would you, Erica? I'd rather,
And Dave, I'm going to make you an attendee with everybody else. We just had a discussion about that. Oh, where'd he go? Yeah.
he disappeared.
Disappeared.
Hi, Leslie. So I don't want to, I mean, we have the meeting open and the public's listening. I don't want to wait too long. But I thought maybe, John, we would start as we did last time with you sort of going through and explaining any changes from the version we reviewed last week. And then hopefully Matt will come and we can and if he doesn't, we'll discuss whether to adopt those changes or not. Does that make sense to the rest of the board? Okay, I'm seeing.
So, Brooke, I'd also like to address, if it's okay with you, the comments and suggestions we received from the work group.
Sure. Yep.
Okay. So, since our meeting last week, as you know, I had put together a revised warrant, and there were several comments that suggested we should put the general bylaw, Chapter 123 regulations first as Article 1, and then Article 2 would be the zoning. And as part of that discussion, there seemed to be a strong there was a strong sentiment that we should maintain the linkage between the two articles. So in the version that is in front of you on the screen, we have done that. And to really tighten it up, I made Article 1 dependent on the passage of 2 and Article 2 dependent on the passage of 1. So this is going to be an all or nothing proposition. They will either both pass or they will both not go into effect. Any questions about that?
No. Any questions from the board? Okay, I'm not seeing anything.
Brooke, I just want to note that Matt is on.
Yeah, I'm here.
Oh, okay.
I think that's a mistake. I think that the way that town council and Judy Barrett presented it during some of the drafts made a lot of sense, because we would have the bylaw could be in effect and working. And then, because I think the zoning is going to be the thing that's going to trip this up. So I liked that, but you know.
Well, Matt, I'm sorry, Brooke. The rationale.
No, go ahead, John.
The rationale, when I originally made these changes, was not to link the two together for exactly the reason that Matt stated. You know, I think everyone would probably agree that the zoning is going to be the bigger lift here. Not just because it designates this as a by right use, but also it requires a 2/3 vote. So the question becomes whether the board wants to be able to enact Article 1, which are the regulations, and have that not linked up to the zoning, so that if Article 1 passes and Article 2, the zoning fails, you will still have the set of regulations in place immediately upon approval of Article 1 by the Attorney General.
Questions from other board members? I have one, but I'll hold mine till Malcolm or Tom. Okay, I'm going to move you guys around so that I can see everybody and while the screen's being shared. Okay. My question to you, John, is what is the legal implication of not having it as a stated use in zoning and regulating it? Are there any legal implications of that? Can it be enforced?
The answer, in my opinion, is yes, until a judge tells us otherwise. Not that I'm expecting that, but the position the town is taking in the litigation is that these are an allowed use in all districts. And a judge is going to decide that question. The whole point of the zoning amendment was to take that issue off the table, get rid of the legal jeopardy, and address the use specifically in zoning. So if Article 1 passes and Article 2 fails, I don't see any adverse legal implications for Article 1. Although I would continue to recommend that perhaps in the spring you address the zoning piece if it fails at town meeting.
Okay, follow-up question. Were a judge to deem that it is not an allowed use based on one of the pending litigation situations, does that change the enforceability of Article 1?
No, Article 1 remains fully enforceable. They're two separate things, Brooke.
Okay.
The regulation would still be in place, but the use would not be allowed. And of course, if we did get a court decision, adverse court decision, our recommendation, and it's no secret, we would recommend that you appeal that decision. So it would be quite some time before the zoning litigation was resolved.
Okay. So given that response, any questions from the board? I actually agree with Matt that I'm not, I think it would be helpful to have the general bylaw in place so that we can get the Attorney General's ruling on it and begin to set up the appropriate infrastructure for enforcement, regardless of what happens in the zoning. I would appreciate it if the former members of the work group could explain the rationale, re-explain the rationale behind the linkage of the two together. I know they have indicated that they prefer the linkage, and I'm just curious, it would be helpful for me to understand why allowing Article 1, now the general bylaw, to pass without Article 2 would be problematic based on their reasoning and rationale. Does anyone want to comment from that group? I see Kathy's hand up. Kathy, if you could just keep it to a minute or two, that would be great.
Okay, can you hear me?
Yes.
Okay, so I just quickly, the fact that we have two separate articles is mostly because of the types of things you can do in zoning versus the general bylaws, so that you couldn't put it all in one article and accomplish what we did. But we always viewed it as a package. The whole thing was a package, so a piece of it couldn't be taken out or not be voted on. So that's why we created the linkage. We felt that it was it needed to be all or nothing. we didn't want the same situation to happen when we had Article 39 and 42, and they weren't linked, so they could go forward the way they did and leave the legal jeopardy there. So for me, as voting for Nantucket Together, that was the linchpin. That was why I could vote yes. And if they hadn't been linked, I would have had to vote no on the articles. So it was very important to me for that reason.
Okay, thanks, Kathy. Peter Kahn?
Can you hear me now? I'm sorry.
Yes,
you?
thanks, Peter. You're unmuted now.
Okay,
Thanks.
sorry. Although I am on the STRWG on behalf of the ACNVT, our position would be, as yours is, Brooke, that and as Matt's is, that we are perfectly comfortable and with the idea of having this not linked in the sense that the new Article 1 should go into effect. If you want, and the only thing we would suggest is that there might be a statement saying that if Article 1 does not pass, then there is no vote on Article 2. In other words, we should not go to a vote on the zoning if Article 1 does not pass. Because that would. But other than that, we're very comfortable with the idea of not linking them, because we do think. Okay, I'm sorry. Go ahead.
That's helpful. I'm gonna try to keep these short so we can move along. Jim Salter?
Yes, can you hear me?
Yes, Jim, thanks.
Okay. Yes, very briefly. I agree with what Peter said. If they are not linked, we feel it's really important that there be a statement saying there will be no vote on zoning, Article 2. We know that sometimes fluky things can happen at town meetings, and we definitely do not want that yes vote for STRs to be in place unless they are rigorously controlled by Article 1. And so that's very important to us, that there be no vote on zoning unless Article 1 does pass. Thank you.
Okay.
If I may.
Thank you, John. Go ahead.
So I don't think it's possible to prevent a vote on Article 2. It's on the warrant. Any voter can make a motion if the two are not linked. And let's assume the scenario is that Article 1 fails. Then you would my recommendation would be that someone makes a motion to not adopt Article 2. That's a simple majority vote. If that motion does not pass, then anyone can make a positive motion to amend the zoning, and that requires a 2/3 vote.
Okay.
So
Thanks, John.
there is
Yeah, but-
somewhat of a risk, obviously.
Well, can we John, can you write it in such a way, like we've written these, that both have to pass? Why can't we write that, that the general bylaw has to pass to go to this? Why do we have to leave this hanging? Can't we put in place that this is, only to be in effect if the first one is voted? Can't that be part of this wording?
Yeah, I think what we could do, Matt, is take out the contingency language in Article 1. So that would be a straight vote. Do you want to amend the general bylaw? But keep in the contingency language in Article 2. Now, having said that, someone could make a motion when we get to Article 2 to delete that contingency language, but there's only so much we can protect against here. But yes, I think, and that's an excellent suggestion, we could take out the contingency language in Article 1 only and keep it in Article 2.
Okay. Thoughts from the board on that?
Madam Chair,
Tom? Yep.
I agree with Matt and the chair that since 64G in Mass General Law gave us the municipality or through our legislative body the ability to regulate through the general bylaw, not having Article 1 pass, even though there was discussion in the short-term rental work group about having them inextricably linked, this does seem like an awful lot of work and good stuff in here to lose by making them both contingent on both them passing.
Can you repeat the last sentence for me, Tom, that you said?
Just that it would be an awful lot of good work and good stuff in here, to use a loose term, to make it contingent on both of them passing. So I agree with Matt's comments and your comments.
Okay. Malcolm, any thoughts on this before I ask if anyone's ready to make a motion?
No, I mean, my thoughts on this all are well known.
Okay. I think Kathy, you have your hand up. I'm gonna Kathy, quickly, or Kathy Baird, please.
Okay, I just want the board to know that there would not have been a consensus and there would have not been anything coming forward from this group had they not been linked. Thank you.
Thank you, Kathy. Mhm. Okay. A pleasure of the board on this item.
I'll move
Matt?
to unlink them and put the general bylaw first and keep the wording in the zoning bylaw.
Okay, so that is make the zoning bylaw contingent on the passage of Article 1, but not Article 1 contingent on the passage of Article 2. To
Yes.
be clear. Okay,
Yes.
great. Do I have a second?
Second.
Okay, all those in favor, by roll call, Matt Fee,
Aye.
Malcolm McNabb,
No,
Tom Dixon,
Aye.
and the chair votes aye. So we'll make that change.
And just a general thought about this, the goal isn't, I think there is a zoning thing we can get to, but I think I'm looking at this as just take one bite at a time. I understand Kathy's concern, but we need to take one bite at a time. If we try to eat the whole elephant, we're not going to be able to finish it. So.
That is where I'm at as well, Matt. Thanks. And I see Tom shaking his head. Thank you. Okay, John, what else? Is there anything else?
Yes, Erica, could you put up the warrant again, please, and go to the definition of operator in Article 1? I have added the words or other legal entity. As I was going through this, I thought that addition was important. I hadn't discussed this with you before, but we do have LLCs and S corporations as well as individuals. So that just makes clear that if an LLC is operating a short-term rental, they would be subject to this definition as well.
Okay, great. Matt?
I highlighted this definition, and the reason I did, I think it ended up being changed sort of opposite of what I think the short-term rental group wants or their understanding. I think it's opposite of what their understanding is. The reason I highlighted this is the definition is talks about leasees and subleasees, mortgagees in possession. My understanding is that we don't want someone renting a property from anybody for 2 months, 3 months, and then subleasing it. My understanding is what the short-term rental group wanted was, a natural person, to be renting, other than the ones that are grandfathered. My understanding is that they wanted a natural person that, a family or a unit, not the ability to parcel it out to a corporation that's going to sublease these and do a bunch of them. So my question was to John was, do we need the leasee and subleasee? And if it has to be in there for state reasons, is there a way to clarify that that's not what we want? Does the, and I would ask so my question really is, and I'd hate to think that we have this wording in there and we're leaving us legally exposed a little bit, because someone could say, geez, it says leasee and subleasee. That's all I'm doing. I'm an operator. It's allowed. So that was my concern. And then I read the short-term rental work group and it seemed like they agreed with that. So I'd like them to talk about it and John to talk about it, just to make sure that we're tight on the natural persons.
Okay, thanks, Matt. John, do you want to respond first and then?
I think it's best if we hear from the work group, Brooke.
Okay, okay. Peter Kahn? Peter, you need to unmute.
Okay, am I good now? Can you hear
There
me?
you go.
Sorry. All right, the work group wants to make sure that, like Matt, anybody who operates an owner or operator of any sort is covered by these rules. So the whole idea for us was that any subleasee, any whatever, even if it's a corporation, is a operator or owner, and they must comply with these rules. These rules cover everybody. And so I think we're comfortable with that, and that and I'd be anxious to hear from town council, but owner operator rules govern here, and a sublessee is an operator. So they fall within this, and therefore there should be no concern that a corporation or any other entity would be doing things that are not allowed.
So Brooke,
Okay, John. Mhm.
so that's why I did not change the definition of operator, because it means that lessees and sublessees will be subject to the same regulations. I think Matt may be addressing a different point, and that is, do you want to allow lessees and sublessees to short-term rent at all? Is that correct, Matt?
Yes, John, that's correct. My understanding is we didn't. I can't rent my house to somebody long-term who then subleases. My understanding is I couldn't do that. And then they could sublease.
You couldn't. It depends what the lease looks like.
Peter Kahn, could you mute, please?
Oh, I'm sorry.
Okay.
And
Matt, could you
and the
repeat that
reason-
again?
Yeah, my understanding is I wouldn't be able to, to lease my house long-term and then somebody else say I'm the leasee and I can short-term rental now. They aren't the owner. They aren't the natural person. And I'm sort of saying this because there is a few homes near a friend of mine that are, that someone does exactly that. They pick off 4 or 5 homes on this one lane and then they rent them all summer. And so I thought that we were trying to stop that from happening. I thought that was the intent. And so I thought it was done in some of the other words. But then when I read this, I thought, well, man, are we opening the door a little bit to something we don't want? So that's why I asked the question.
I understand the question. So from what Peter Kahn said, we want to make sure anyone who is currently that everybody's subject to the rules, but but Matt's saying we shouldn't even allow lessees or sublessees to do short-term rentals at all. So John, how would that be accomplished if that's the intention?
I don't think we should change the definition of operator. I think we should leave that as it is, but I would suggest that perhaps in subparagraph L, we add a sentence that any dwelling unit that is subject to a lease with a change of occupancy in excess of 31 days shall be prohibited from short-term renting that dwelling unit. Something like that.
Okay, Matt, does that sound?
I'd like to hear from the short-term rental work group. I'm wondering, is it any? Like if I rent my house to Brooke for 21 days, can she rent it out 4 times for 3 days each? I think it's just I'm not sure that this has really been dealt with. I think it wasn't dealt with because people expected that wouldn't happen. But that's why I'm asking.
Okay, great. I'm going to ask Kathy Baird to respond, give us some input.
Okay, I think there was a few things that we looked at. There was language that in the original Article 39 above where it defines who can register. And you could have the owner register, or it could be somebody who operates the, manages the rental, like their property manager or something like that. But you had to get your certificate in that name. And then since we thought that definition, which correlates with the operator definition, then was subject already to the change in occupancy. So you couldn't have more changes in occupancy than anyone else. So we didn't specifically address the lessee or sublessee, but it is permitted now. So we didn't change that.
Okay, thanks, Kathy. Jim Seltzer?
Yes, thanks. I agree with what Matt is saying. I think we were hoping that what was there would prevent that because of people needing to register as an operator. And maybe that's the case, but I think it would be better to go a step farther and do what Matt is suggesting, and perhaps language like John Giorgio just suggested. I think it's important to address this issue and address it now. So thank you, Matt.
Okay, with that input, the pleasure of the board.
But I'm gonna suggest adding or other legal entity to section 3A, where it says no person shall operate an STR without a certificate. I think we should also put in there or other legal entity.
Okay,
I assume there's a consensus on that.
I agree. Malcolm?
I agree.
Okay, Matt?
I'm trying to understand it, what we're saying. It was saying, or other legal entity. What's the rationale for this?
I
So
want to,
how does it
I
help?
want to make, notwithstanding the Citizens United Supreme Court decision, I want to make it clear that a corporation needs a certificate of registration, or an LLC needs a certificate of registration. So those other legal entities, in addition to just a person.
So this is to make operator and who's eligible for certificate
Consistent, yes.
consistent language. Okay. So I concur with that, Matt. Does that make sense to you now?
It does, but I don't, but this isn't meant to deal with the issue I have. This is just meant to make those two things. Okay, then I'm
Yeah.
fine.
Yes.
Yeah.
We're starting there with those,
Okay.
and then the second one, would be this question of adopting the additional language in M to prohibit lessees and sublessees from operating a short-term rental. So do we have consensus on the addition of the other legal entity in those two spots under operator and under 3A?
Yes.
Okay.
Yes,
Okay, great. So that's by consensus. And then, and now the recommendation John made to address your concern, Matt, of, John, if you could just repeat the language, we're in section M, 123-3, section M. For anyone following along. Erica, thank you very much for
I think
getting us
I
on
would
track.
rather put it in L.
Okay, L?
No dwelling unit that is subject to a lease shall be eligible to receive a certificate of registration. And we can say for a short-term rental for clarity.
John, could you please
Okay.
say again exactly where in L that is to go in?
At the very bottom of L, a new sentence, Libby. No dwelling unit that is subject to a lease, Matt, that takes care of your issue, shall be eligible to receive a certificate of registration for a short-term rental. Does that work, Matt?
that does. I'd like to hear from the short-term rental work group and whether they, whether they had conversations about this, whether this makes sense to them or not. I just want to, this is kind of sort of the stress testing I was asking for and talking about, we're kind of doing it, trying to figure it out on the camera. It's difficult. So I'd like to hear a little input to make sure it's not completely, but I like it.
Okay. Anybody from the former work group members want to comment on this? I mean, we did hear a few comments on this subject, but anything specific on that language? Okay, no one's raising their hand.
Then I suggest we move on. I'll make a motion that we add this language.
Okay, do I have a second?
Second.
Okay, second from Tom. By roll call, Matt Fee,
Aye.
Malcolm McNabb,
Aye.
Tom Dixon,
Aye.
and the chair votes aye. So that's unanimous 4-0.
And a comment,
Okay.
a quick comment, if this, this could be adjusted slightly at town meeting, if there's a valid reason and argument to do so.
Yes.
If we haven't thought of it, right.
Yeah, exactly. So I would say, this gives others the opportunity to make their case.
Okay. All right. John.
Subsection F, there was a misspelling in the original chapter 123. Both Libby and the work group picked up on it. Complied is being changed to, I'm sorry, compiled is being changed to complied.
Great.
Okay.
Was that a test you put in there, John, for all of us?
Yeah. It's my dyslexia at work.
Okay.
Oh, so those are the only changes I'm proposing to Article 1. Article 2, we're going to include the contingent language that was not taken out by the board. All right, going to the work group's comments.
Sorry, can you tell me where the contingency language in Article 1 is, just so I can do a quick strike through?
Yes, so it's everything. Sorry. So it begins with provided that the provisions,
What section?
it's in the introductory paragraph of Article.
Okay, thank you.
Starting with provided. All the way down to the end, to Attorney General. Yep.
Thank you.
Thanks, Erica.
Oh, now going back to the work group comments that we received yesterday. We've addressed the linkage issue. We've addressed the lessee and sublessee issue. There was a proposal, I believe it originated with the two Peters, in paragraph H, to add the reference to compliance with 123 3H. I'm sorry. To make a change in subsection M to make sure that they comply with the requirements in H now. And H, just to refresh everyone's recollection, is the grandfathering provision. And in H, we have added this concept of proof of the state registration and proof that the owner has collected and paid the excise tax in 1/3 calendar quarter. I am not recommending that we make this change, because if you look in H, if you go down, you'll see that if you meet those criteria, that unit, it says shall be exempt from the requirements of I, J, K, and L of this chapter. However, I added the sentence, the provision of subsection M shall, however, apply to such short-term rentals. So I believe I've already addressed that issue. And again, this is the grandfathering provision. And I don't want to load it up with references to substantive regulations, because that's going to raise the question, well, why aren't all these other substantive regulations put in subsection H? I think the fact that we say M shall apply, even though they're exempt from the other provisions, I think that addresses the concern that was raised.
So I have a question. The end result of this is, will someone who has shown that they paid rooms excise tax as described in H be eligible to do 9 contracts versus 5?
Versus 4.
I mean, 4. Every time I do this, I say 5. My
Yes.
apologies.
They will be grandfathered, except with respect to subsection M, which is the 9 contracts. They will be subject to that limitation of 9 contracts.
Right. Okay. So until the property turns over.
Once
Okay.
the property is turned over, they will be subject to the 4 limitation.
Okay. So, Peter Kahn, I know you had a question about this. Let me ask the board first. Any questions on this?
None from me.
Okay, Malcolm.
No.
Okay, Peter Kahn, comment, question?
Okay, can you hear me?
Yes.
Okay, this is all contingent on exactly what the board intended in passing H, as to whether or not clearly they wanted as we understand it, you wanted to grandfather in with those, with the preconditions of registration, et cetera, 9. But it was our understanding that, as Matt Fee expressed it, all others would be 4. If that's the case, then the way M currently reads, if you didn't register, you didn't do anything, you'd get 9. And it was our understanding that the board wanted to put the brakes on this a bit more and say, hey, if you didn't register before the town meeting, and if you didn't rent one time between 2019 and 2023, and if you didn't pay your taxes, you don't have the benefit of 9. You only get 4 for anybody. And if you leave M as it is, it will give 9 to everybody, and it's inconsistent. It'll effectively be inconsistent. You will not have accomplished anything. So that's why we put it in the language to make it clear that only those people who have registered, et cetera, get 9. Everybody else, their starting point now, if they haven't rented previously, is 4.
Okay. John, Giorgio, thoughts, or shall I take another comment while you think on it?
That's fine. Take another comment. Brooke.
Okay, Kathy, Baird, Peter, if you, yeah.
Okay, so we had a lot of discussion on this one, and they originally, what John Giorgio said was what we had put forward. That was the rules, that the way they're stated. Then there were some who felt that Matt wanted to change that, and so we weren't really sure what the intent of the board was. But at this point, the reason we were trying to not, one of the things you don't want to do, or people recommended not doing, was taking away rights that people had or felt they had, or investments that they may have made in their home that at some future date they might want to. They've owned a house for 20 years, and maybe that was their retirement plan. They were going to rent it out. So they're not short-term renting now. That may have been part of the plan, and we didn't want to prevent that from being a possibility for people. But we did want to stop the rush to register. And we felt that that's what the wording that currently exists does, but it does not prevent, a teacher who buys a house and maybe they want to rent it for the summer because they can go away. They wouldn't be allowed to do that, and we didn't want that to be a bulwark and a barrier. So it really puts the brakes on a lot more if you do that. So that's the rationale we had for that, leaving it the way it is.
Thank you. Okay, thanks, Kathy.
So-
That John?
So Kathy, if you own a home now and you don't short-term rent it, and this bylaw takes effect, you would be able to apply for a certificate of registration.
Right,
And under M, you would be limited to 9 changes in occupancy.
yes,
In the grandfathering provision, if you have a certificate of registration from the state and you meet the 2 criteria, you are still limited to the 9 changes in occupancy, because the grandfathering provision expressly states that you are subject to M, which is
Right.
the 9 changes in occupancy. So I think that accomplishes what the work group was looking for or intended. But you correct me if I'm wrong.
Kathy?
oh, okay, I'm still on. Yes, no, I agree that I interpreted the exact same way that you do, and I think that was our intent. That was the intent of the short-term rental work group. There were some folks that we were talking about later that heard something different at the board meeting last week. So if that's not different and it should stay the way it is, I'm personally fine with that. I think that was our intent to begin with.
Okay, thank you, Kathy. Matt, you unmuted. Did you want to?
Yeah, as long as it's doing that, that's great. You know, it shouldn't be opening the gates to everybody. In the case of a teacher, there's a hardship, there's a waiver, there's a hardship process. So I think we can feel I feel comfortable that if a teacher came and said, I was scraping by, I could barely get my house and I need to rent it, all summer, as much as I can to be able to stay on the island and live here and teach kids, I would think that the hardship waiver would kick in. So I'm comfortable, with as long as, but what I am worried about is Peter Kahn saying that the wording here doesn't do that. So, if I can make a motion, I want the wording to, let town council dig into it and make any changes necessary to ensure that the wording does what we think it does.
I'm already quite comfortable, Matt, that the wording as presented does that. And again, if you add this to paragraph H, it's going to call into question all of the other subsections that have substantive regulations. Why aren't they included as well? Okay, I think it's much cleaner the way I've drafted it, and I think it accomplishes the intent of the work group. And this, I will say, this, through nobody's fault, this bylaw is already pretty complicated.
Peter Kahn, did you have something you wanted to add to that?
Can you hear me now?
Yes.
Yeah. Yes, please. With all due respect to town council, and I'm happy to have a discussion offline if you allow me to do so with him. The current language of M is in conflict with the current language of H. And Maxie is absolutely correct that the paragraph N will accomplish this with our language. In other words, there should be no concern that somebody, a teacher, whatever, needs the 9 and can't do it because he or she will have access to N and they can then petition. But if you leave it as it is, if M is not changed to reference back to the concerns of M is not changed to reference back to H, then you're going to have a situation where everybody gets 9. And you don't want that. You only want people who have a need for 9 to get 9, who haven't done it before. And that is, and that's allowed by N, Nancy, N. So I would be pleased if you would allow me to have a conversation with town council to try to straighten this out. I think, as lawyers, we can accomplish that.
I don't expect that we'll have time for that. So thanks, Peter. Jim Seltzer.
So I have a question when it's my turn.
Okay. I'd like to hear from Jim, John, and then I'm going to see if I can summarize the two sides of this. So I want to hear from Jim and Karen.
Okay,
quickly.
thank you. Thank you.
Yep,
So
Jim?
Kathy Barrett is absolutely correct that our original intent was for someone who owns a property and has never rented it could start with 9. However, when the select board voted last Wednesday to tighten up the regulations for who could be grandfathered, we felt in our discussions, most of us, not all of us, but most of us felt, well, we should respect the select board's wishes, and we should therefore also tighten up the requirements for who can start with 9 instead of 4 in the high season. And if we do what Peter Kahn's language suggests, which I agree with, it means that the ability to have 9 rentals in a summer would also depend on having previously rented, the taxes, all that we got for grandfathering. We thought it would make it more consistent. True, it wasn't our original thought, but we saw that the select board was moving toward more regulation, more restriction, and we were really just trying to be loyal in our change to what we thought the select board wanted. And that's why I do support the change in language that Peter Kahn suggests, because I think it helps to put into effect what the select board voted for last Wednesday. Oh, and by the way, Brooke, later, I do have one more typo, but for later.
So I'm going to thank you, Jim. I'm going to take a moment to make sure I'm clear on what's we're talking about here. The two options, as I see it, John, are we're only allowing 9 contracts for people who have rented during the summer and can prove that they have done so through this season, at 1 year through this season. That was my intention last week, that someone who doesn't have a history of renting in the summer does not have the protection of the 9 contract. It's not a protection that goes into the future or someone's future plans. It's about who has needed to do this, who has had the need to date to do this. That was how I saw the discussion Wednesday night. The alternative is what some members of the work group have said, is that they would like to protect the 9 contracts for anyone who currently owns a property on Nantucket until that home is sold. And I think that is the question before us, is which direction does this board want to go with regard to that? And if I could just poll the board members and see what their intent was last Wednesday, and then John, direct you on how to make that make our intention happen in the language. So Matt?
I'm with you, Brooke. I agree. It should be tighter.
Okay, so to say the only one who's protected with 9 contract is someone who can prove that they've already done summer rentals.
Yeah, like you described last week. Yes.
Okay, great. Malcolm?
I agree.
Okay, Tom?
I agree. I guess my one question would be, of course, it's subject to the moderator's determination on an amendment, but could somebody at town meeting floor make that amendment to do the opposite? But I agree.
Okay. So I believe we have consensus from the board, John, that the intention is to only protect 9 contracts for the person who qualifies under the having a registration with the state and proof of having rented in a third quarter between 2019 and 2023. Can that be accomplished?
I apologize for taking my time here.
Quite all right. I apologize for putting you on the spot.
And that would go in M.
Let me ask you this, John. Is our intention clear to you? And are you
Yes.
comfortable that you will be able to find the appropriate language?
Yes, I mean, I think I
If-
would use Peter's language, but I just have to, I think Peter's language, I want to make sure Peter's language accomplishes that intent,
Okay,
but, so anybody holding a certificate of registration, whether they had one before or after the effective date of this bylaw, is limited to 4 changes in occupancy in July and August unless they comply with H, meaning that they have a history of rental, then they get the change in occupancy up to 9.
correct.
Yeah, okay. I think Peter's language accomplishes that. And if that is the will of the board, then what I would recommend is we just revise M accordingly.
Okay. And I believe we have consensus on that from the board, as stated earlier. Is there any board member who is uncomfortable with us moving forward or directing town council? Okay, hearing none. Are we there, John?
Hold on.
I'm going to take a comment from Jim Salzer while you're thinking.
Thanks, Brooke. This is just to point out the typo. I think we caught it last week, but it may have slipped through. Is it okay to give the typo now, Brooke?
Sure.
Okay, it's in H. It's, I think, 9 lines down after the word conveyed, which is the 3rd word. I mean, there's just 2 commas. That's all. It's tiny, but I figured we might as well correct it.
Yep. Found
Yeah.
it.
Okay.
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 Great. Thank you.
So now the work group had a few questions that I wanted to address.
Excuse me, Madam Chair, before you go on, I have a break in 10 minutes.
Okay. All right, John, can we wrap it up in 10 minutes, do you think? I
Yeah,
think
sure.
we're close,
It-
Malcolm.
It's, yeah, it's only 2 things. So the question is, it involves subsection J. And I wanted to make it clear that the way it's written, an LLC, trust, or S corporation could change their ownership structure and still continue to be eligible to receive a certificate of registration or a renewal, as long as every shareholder, partner, or member remains a natural person. That's the way J is written, and I want to make sure that's everyone's intent. So I could reorganize my LLC, kick my son out and add my daughter as a member. And that doesn't affect their ability to continue to short-term rent that property. And then the
Does-
other, okay,
Matt has a question about that. Matt?
Yeah, so John, so let's say I have an LLC and my house is owned by an LLC and I want to kick out my son, my daughter, and myself and add Brooke. She's buying it, Brooke and her family, but they're buying the LLC, not the property. Is that, they're still real people? Does that
Yes.
mean they bypass the family thing?
I'm going to assume Brooke is a natural person. And so, yes, that would be allowed.
So this as written would then, if I'm hearing you, would then mean that the idea that the 9 goes away, as long as people are buying the corporation, the 9 never goes away. As long as they list natural people. And I think the intent of the work group was that to avoid that families, they were giving an advantage to families and passing it to family, but I don't
Okay.
think their intent is to pass it to a completely different family.
No, Matt, if the LLC sells the property to a new buyer, that new buyer is subject to the 4 limitation. If you substitute Brooke for one of your children, then they continue, it meets the criteria, then they can continue to rent on 9 changes of occupancy.
Can I follow up?
So-
I just want to
Yeah,
make
go
sure
ahead, Matt.
there's no loophole. Because I know that there's that people have LLCs and they'll sell the LLC. They didn't sell the house. They sold the LLC. Is there, we want to make sure, and maybe some of this is going to be in the registration or in the oversight portion, but we want to make sure that we didn't include any big loopholes here. That's all.
What is the loophole, Matt?
As I see it, if the court, the next LLC is owned by by natural people, but it isn't my family, it's not, it's not we want to be like the land bank, I think, where, you pass it on to family, you don't pay the land bank fee. We don't want to be like, oh, I'm passing it on to natural people so they can still do what I did. You see what I'm saying?
Yeah, I think, John, the question is, if the ownership of the property stays in the same name of the LLC, but money changes hands in order to change who are the partners in that LLC, you've effectively sold the property, but the ownership didn't change under this provision.
I think Matt should be a lawyer.
My parents thought that too, but I liked bread too much.
Does that make sense, John?
Yeah, but I hear Matt saying something different or something in addition. He's fine if the new natural person is a family member as opposed to some random guy off the street. Is that right, Matt?
Well, no, I thought the intent of the short-term rental work group can talk about this. I thought their intent was that the home, properties could be passed on to family members with the 9 in place and with the certain rules, but they were not to be passed on to other entities or other people. And Jim Salzer or Dave Iverson, one of them can correct me. And I just want to make sure if that is their intent, that is what this does, that I think this might be opposing that slightly.
Okay, we're running up against Malcolm's deadline. I want to hear from John Kitchener and Jim Seltzer quickly, please. Go ahead, John. Oh, you need to unmute. John, there we go. There we go.
Thank you, Madam Chair. Very, very quickly, this is something that I've actually been through, and that's why I brought it up to the group. I think we most times we talk about LLCs, we insert the name, the word family LLC. That's not what this is about. This is about a Greenwich, Connecticut LLC with 3 members, buy a home on Nantucket, rent it, short-term rent it, and then at some point they sell the LLC to 3 completely unrelated people, just another 3 investors. So yes, they're all natural people, but they're investors. One group of investors sold it to another, but the home title didn't change. It's still in the LLC. And that's what I would like to try to make sure we, regulate against that happening. But I have no idea how to do that because this is something I had to do myself one time with a business, not a property. But that's really my thought. It's not about family LLCs. It's about investor LLCs, of which there, I think, are a lot. Thank you, Madam.
Thank you. Okay, Jim, quickly, please.
Thanks. Yes, I completely agree with what John said, and I agree with Matt's concern, and I don't know how to solve it, but I think it's something that we need to look into. Thank you.
Okay, thanks. John, does that make sense?
Yes, I think it would go in, I'm thinking. I think it would go in H. So
Okay.
any change in the membership of an LLC, other than the addition of a family member, shall
Constitutes it.
shall result in the LLC being reducing from 9 to 4, right?
Yeah.
Is that what you're trying to accomplish here?
Yes. Matt, does that sound?
Yeah, that makes sense. And it almost, we should all, we don't have to reinvent the wheel. We should be doing what they do at the land bank, and they have the ability to, to go behind the ownership and make sure they get paid. We want to make sure we're doing the same level of have the ability to do the same level of oversight.
Okay. Other board members, does that make sense to you? Any questions, concurrence on that by consensus, Tom?
Madam Chair, I'll make a motion to add John's language that he just suggested.
Yeah,
Second?
I have to massage it a little bit, but I assume the board will trust me to get it right.
Yes. Is there a second?
Second.
Okay, by roll call, Matt Fee,
Aye.
Malcolm McNabb,
Aye.
Tom Dixon,
Aye.
and I vote aye as well. Okay, is there one more, John?
There's one more issue I just wanted to address. And that's the question, here it is. Would the transfer of ownership of an individual or family-owned STR in and out of a trust LLC or S Corp be considered a sale? And my, yes, so I will address that in this change. So if a
Okay.
dwelling unit is bequeathed to a person or other beneficiary, then they would continue to have, that would not affect their change in status. They would be continue to allow the 9 changes in occupancy. But if the trust LLC or S Corp were sold, or if there is a change in the membership other than to a family member, then they would lose the benefit of grandfathering.
Okay. Sound good? Any concerns from the board?
I'm fine with that. It sounds good.
Okay, all right, great. So I think we are at the point of, Erica, if you want to take down the screen share, I think we're at the point of inviting John back and voting to reaffirm the adoption of the warrant as amended. Does that sound right, John? Legally speaking?
Yes, it does. I would ask one thing, Brooke.
Yep.
I see where Judy has come on the call. I know I would ask if she has any comments or questions, since we've been the two amigos on this. Are you okay, Judy?
Thanks, John, for
with
that.
what We're
John,
doing.
the last thing I want to do is muddy the waters at this point. I'm actually fine. I've been following this and I don't have anything to add. But
Okay,
thanks
thank
for
you.
asking.
Okay, yes. Thanks, Judy. Okay, Don, you want to take it back over? Has Don left the building?
Hi, I'm here. Sorry.
Okay, that's okay. So,
Are we done?
yes, so I'm going to make a motion to adopt the warrant as amended by this discussion and the motions and votes today, subject to town council's final language.
I'll second that.
Okay, all those in favor by roll call, Brooke Moore,
Aye.
Malcolm McNabb,
No,
Tom Dixon,
Aye.
Matt Fee.
Aye.
Okay, Don Holgate, aye. Is there a motion to adjourn?
So
So moved.
moved. Second.
All those in favor by roll call, Brooke Moore,
Aye.
Malcolm McNabb,
aye.
Tom Dixon,
Aye.
Matt Fee,
Aye.
Don Holgate, aye. That's unanimous. Thank you, everyone.
Thanks to everyone.